I would imagine that would have placed them in a position that they were not able to have access to the rest of the bundles of documents that we intend to rely on. I thought I should just bring that to the attention of the commissioners. Having done that, Dr. Young, if I may turn to you, when we adjourned, or shortly before we adjourned on Friday, you were giving evidence in respect of the ADS's best and final offer that resulted or elicited a response from the Department of Defense, and that you were in the process of giving evidence in relation to Annexure RMY 30, which appears at file 3 of the bundle of documents. And at the time we adjourned, you had just finished dealing with the issue of the IMS. Do you recall that?
Yes, I recall that.
And when we adjourned, you were about to start dealing with the system management system of the combat suite. Would you like to take it from there?
Yes, okay, I shall do so. Also, just to put on record, I only have my digital documents. I don't have paper documents with evidence bundles in front of me. Okay, where we left off, sorry.
Do you have a copy of your statement?
My own copy of the statement, and I have my digital copies of the evidence documents in front of me.
You will notice that the aspect you're dealing with appears as from paragraph 225 of your statement.
Yes, I'm aware of that. I'm just putting it on the record that I don't have either a commission witness statement or evidence. So I'm working with my own witness statement, and I'm working with my digital copies of my evidence documents. It's just for the record. I'm not making any point of it.
You can continue then with your evidence.
Okay, we were at paragraph 13, which is the information management system. And now that I come to think of it, I don't think that we'd quite finished the whole thing, because I don't think I'd addressed the IMS study. But be that as it may, just so that there is a proper, rather have an overlap than a gap, item 13 on this letter addresses the information management system, and it is a particularly important point.
Commissioners, the annexure we're dealing with appears at page 970 of the bundles of document. It is file 3. The paragraph number dealing with the information management system that the witness is referring to is at page 970 of that document. You may proceed, Dr.
Okay, the paragraph 13 covering the IMS says that the offer of 7th of April had an IMS cost at 47 million and included a fifth system, a mistake acknowledged by yourselves. Thus, the offer actually was a total of 42,860 million. There is no rational explanation for the current price of 77,157 million, an increase of 80% within a 2-month period. The current price is totally unacceptable. What I'd like to say is this: when I wanted to address the IMS best and final offer, which is just before this, in my witness statement, our documents were pointing at the incorrect document, being the NDS best and final offer, rather than the IMS one. I did say that it was a discovered document, and indeed it is. It is there, and although I stated the price that the IMS best and final offer had, just for the record, the discovered document has a index DT1-0429. We might come to it again, but this price that we're talking about here, of 42 million, basically is either identical or the same as that price. So that explains my emphasis on the difference in price between the 42.8 and the 47 million. If I may say myself, it is indeed unacceptable, just from the simple point of view that it is indeed a mistake, that 47 million actually comes out of an offer that we submitted on the 22nd of December in response to a request for offer. I think it was from ADS on the 15th. So for whatever reason, whether it was inadvertent or not, the same prices were still in, despite them requesting a best and final offer and us giving them a price. For whatever reason, I don't know, but it's a fairly fundamental mistake, because of course it exacerbates this whole issue of this very substantial price increases, which eventually led to the deselection of our IMS.
You then deal with the IMS study at paragraph 14. What does that relate to?
Yes. Once ADS and Thompson had started viewing, for want of a better word, the IMS in a negative light regarding risk, I'm talking about here, as we talked about on Friday, commercial risk or business risk, there was obviously interactions going on with the project team and probably the GFC about a mechanism for addressing that risk. And although I was aware of something at the time, nothing was addressed to me. I wasn't engaged on this at all. But what is clear is that an IMS study had been proposed by somebody and a price put to it. And in fact, so obviously a price had been put, and I'll tell you it was a price of 12 million, because we'll come to that next. But what this response to ADS's BAFO says, this price is far too high for the envisaged work to be undertaken. It is our considered opinion that this item should cost less than 10 million rand. If I may say so myself, as an expert, I would totally agree with that statement. In fact, one could divide it by half and it still would have been sufficient.
What did this IMS study relate to in particular?
I am a little bit more aware of it, having read the documents, in my preparation for my various legal actions, including this one. But it seemed to be they were going to get an independent expert. I don't know whether I'm aware of a particular name or entity, but a company or an individual, but a completely third party having nothing to do with this. And my guess was probably not even a South African party, because there aren't too many experts in this particular field in this country. And then work together with the GFC and ADS's experts, system engineer experts, as well as ourselves. In fact, somewhere in the documents, I don't even know whether I discovered it. I'm sure I discover it. I don't know whether it's a produced document. There is indeed a kind of a timeline that depicts the time schedule over which this IMS study would be undertaken. So obviously, it was a fairly well considered proposal. Of course, the price.
Thank you. Now, before we go to paragraph 226 of your statement, where you introduce the risk premium that was attached to the price of the C-squared, I-squared systems, IMS, is there any point you need to deal with in this document, RMY 39?
Yes, although it doesn't necessarily directly involve the IMS. We have got the document open in front of us, and it certainly is relevant to both ADS's best and final offer, and which we're coming to, unfortunately, next, as well as the project team's response there too. So I think it is it's practical approach to address it right now while the document's open in front of us.
Can you proceed to do that?
Okay, the next point after 14 is the system management system. Of course, it's not just that I want to address that. The SMS and the other points that I come to are individual, self-standing aspects of my evidence, which I address in far more substantial detail later. So it certainly is appropriate to address it now as a kind of a reference point or point of departure. That being said, talking about the system management system, and it also goes to show this strange pricing methodology that I mentioned on Friday as kind of being, I think, all over the place, but mainly upwards. Anyway, this response from the JPT, Joint Project Team, says on the 16th of April 1999, ADS offered the SMS at 29,647 million. In the scope of supply of this offer, there are 4 digital video recorders listed in the scope of supply. In the current offer, the SMS price is listed at 30,756 million, and the DVRs are listed at CFE, which means customer furnished equipment, which so it comes for free. The current offer is unacceptable. Kindly offer the same price and scope of supply 16th April 1999. Kindly also clarify the remark that there is no, and the rest of that phrase has been redacted unlawfully, but I can't make out what that is. Now, at this juncture, if I may say, I can't quite remember what we've traversed so far, but just to put it in the context, is this ADS offer for the SMS was a competitive offer with our own. And we were pipped to the post only after there was a 12.5% markup added to our price. And at that stage, we just were underneath, we were slightly over the ADS's price. I haven't analysed it recently anyway in terms of this increase of price, but it just goes to show that after there's a competitive bid, prices don't still seem to stay the same.
Now, if I may then direct your attention to what the subject matter that you're introducing, that is the price with the risk premium that was attached to it.
No, if you don't mind, there still are, as I said, there wasn't just the SMS, there is a whole bunch of relevant aspects. I've highlighted them in my digital version, but you will be able to see that there are blocks. They were red blocks, they're now probably black blocks around various other points that are very important and relevant to address, as at least in an introductory way at this point.
Could you just take us through those points quickly?
Okay, this is a brief one. We've talked about the combat management system before. This is addressed in point 18, and there's something that doesn't mean a lot to me, but it's certainly obviously relevant, and that is what I've highlighted in the block there, the PDF block, as aerospatial decision and its MAPS functionality. I'm not sure what that is, but certainly it is part of the combat suite architecture and the way that the combat management system connects with the surface-to-surface missile, at least its control system, which certainly is relevant for a later point. Come to item 20. Similarly to the system management system, the JPT, the Armed Corps Navy DoD Joint Project Team, requested a competitive bid for the navigation distribution system, and that was where our price was substantially lower, something in the region of our price of about 12 odd million compared to ADS's price of about 18 million. Certainly my impression at this stage was that the C-squared R-squared NDS had been selected, and certainly documents which might have been subsequent to this, which are also on the record, certainly discovered documents, show that very clearly. In fact, we eventually won this and we executed this contract, so we must have won it. But just to show the conduct of what was actually happening at this time, this actually bizarre conduct, if I may say so. Anyway, this response says, based on an offer of CCII received on the 16th of April 1999, the cost for this subsystem, including the ADS fees, this is the 12.05% margin that was added, was calculated to be 15.492 million. That's our 12 odd million with the 12.05% added to it. The current offered price of 22.040 is therefore unacceptable. We expect the most cost-effective solution to be offered, not exceeding the 15.492 price offered to us for the subsystem less than 5 weeks ago. So it shows, even though ADS had been instructed that C-squared R-squared system had actually won that, they still included their own. And whether I come to it or not, certainly some of the spreadsheets, the costing spreadsheets that are relevant at this time also show, despite the decision having made, that the ADS system at this price was still included. I'm not quite finished yet. I'm just giving myself a break and your opportunity to say something.
If one has regards to the comments made by the DoD in this letter with regard to the prices that were included in the best and final offer that was presented by ADS, is it fair to conclude perhaps that the best and final offer that was submitted presented prices which were outside the budget or the ceiling that was set out and approved by Cabinet for the acquisition of the combat suite?
There can be no doubt about that whatsoever. We are going to be addressing that in documents coming up, but just seeing it's Monday and we last traversed this on Friday, the spreadsheet that I showed just preceding this, I think indicated what is now referred to as the April price. That had a price excluding VAT as 2.607 billion. I think if you include VAT to that, it comes to just over 3 billion. Now, just to emphasize your point, the Cabinet approved ceiling budget for the Corvette Combat Suite in April or May 1998 figures, following the comprehensive cost and risk audit undertaken, was 1.470 billion. if one escalated that to the December, now we're effectively talking about now a December financial baseline. If one escalated that, in fact, it's addressed in one of the ADS letters coming up in more detail, that could have been 1.9 billion. So at this BAFO stage, we're talking about a difference of 3 billion to 1.9 billion. In fact, the ADS letter, which I'll address, actually talks about a reduction of 1 billion. So to answer your, in a nutshell, it's still far exceeds the baseline and the expectations between the negotiating parties at this stage. And even though this was a BAFO, a best and final offer, it was still, the prices were still very substantially reduced by at least 300 million, if not more, in another round, which I'm going to address shortly.
Could you then just deal with the last issues that you need to deal with in this letter? I see there's quite a lot of reduction in the document that you're dealing with.
Yes, very unfortunately, because we're coming to the next point, 26 on my PDF, page 4, so it's the fourth page into your document in the bundle. Although the heading is not redacted, the rest of it is.
That paragraph appears at page 971 of the bundles. You may proceed.
Yes, it is indeed greatly unfortunate, because I have now had to work not just with guesswork, but with a multifarious repository of various documents referring to the SSM and the prices and the quantities, etc. And if I may put on the record at this stage, it is also a document that I specifically requested for the purposes of these proceedings. The documents regarding the actual request for offers and responses from the supplier, being Aerospatiale, and these documents, despite me requesting them, I think going on 2 years ago, I have never received. So I will be working on the SMS from what I have, and what I have is also redacted in the critical areas such as this.
What issues do you then want to raise with regard to the surface-to-surface missile?
Well, certainly later, it is a very major point. It's a self-standing theme of my witness statement, but that will be addressed in that theme when I come to it. But I will also be addressing it very shortly in the next 2 or 3 documents that I'll be addressing after this one.
Would this then be an opportune time to leave this document and proceed with the other aspect of your statement?
Yes, I think that's fair to say that.
You can then deal with the risk premium that you refer to at paragraph 226 of your statement.
Yes, just to gather my own point together. Up until round about this stage, the baseline for the combat suite, we talked about baseline at some length on Friday, included the IMS. The spreadsheet, something I omitted to say when I showed the previous spreadsheet, the one that referred to the price of the 2.607 billion, it had an IMS price there, and the IMS was indicated. What I didn't say is that the competitive product to the IMS, being this Detexus system from maybe Aerospatiale at the beginning, which became a Thomson system, was indicated on that spreadsheet as well, although it didn't have any pricing. So clearly there was something in the works right from that early stages of April. I think it was around about the 7th of April. Be that as it may, is at this stage that the various price increases, unexplained, many of them, wrong, some of them wrong, lead to this price that I referred to in my paragraph 226 of 89,255 million. That was a price based on our best and final offer price. That's why I emphasized that point a little while back. Our price being about 38 million, excluding VAT, and then with the markups that ADS were allowed to add for system-level integration, integrated logistics support, etc., that came to around the 44.3 million, which I referred to in 226. And then if one does the arithmetic, that clearly means that there is a risk premium of 44.9 million to bring it to the offered price of 89.255 million at this particular point. Now that is for the risk premium, which included the 10 million referred to in the previous letter, but actually 12 million as quoted by ADS.
Would it then be fair to infer that with the risk premium of 44,951,000 being lumped onto the price which is your best and final offer, the price that was arrived at for the IMS, for CCII Systems IMS, that price became uncompetitive?
Yes, maybe uncompetitive is not strong enough word. It actually became untenable. And in fact, it became so untenable that at this stage, we're talking about the 26th of May stage, you'll see that the BAFO letters that I'm going to come to are dated the 26th of May 1999. This issue was taken to a MINCOM, the Ministerial Committee meeting of whether it was the 26th or the 27th of May, but I'm not sure. But it was at this stage, it was taken to the Ministerial Committee where the IMS was particularly addressed, and this particular issue of cost and risk was addressed. This issue was taken by, I think it was formally on the record. I'm talking about the record of the notes of the meeting. It might have been put verbally by Jayendra Naidu, who was the chief negotiator, but it was in support there was Chippy Sheikh. So Chippy Sheikh clearly took this issue to the MINCOM, and they made a decision that the price could not be increased. Now that's quite a significant point, because when I come to the analysis of prices of the combat suite in the next few points after this, you will see the significance of that. But nevertheless, they made that decision that the Department of Defence, or the budget, the ceiling budget, could not afford to carry that extra cost, and basically that was at least the beginnings of the end of the IMS in the baseline.
Now, based on the price that had now risen up or increased to 89.2 million for CCII Systems IMS, was your company requested to furnish any guarantee for the risk premium that was sought?
Well, if I may just correct you, the issues of guarantee and risk are actually separate issues, certainly in this particular context. I will answer them both. We've been addressing the requests for offer both from the joint project team to the consortium. The early days it was to the GFC. Later, when it became clear that ADS and Thomson were joining that consortium as a higher level consortium, there were requests from ADS to us for best and final offers. In this particular instance, we've addressed in some detail the request from the JPT to Messrs GFC and ADS for best and final offer. I am unaware, maybe I missed it in the fine print, but I am not aware of any specific request that risk either be specifically requested as a kind of extra or identified as a separate part. Now, going back to Friday, we remember or maybe even Thursday, we remember the very detailed cost and risk audits in the format that the JPT requested. And although they requested us to address a risk, there was no addressing of risk in quantitative terms. Okay, so that I can say that I'm unaware of ever being asked to provide a risk provision in financial terms independently. In terms of a performance guarantee, that is something different, certainly in this context. And I will also say, because that comes up as an important point, actually quite later in the chronology of this total acquisition, in fact, almost at least several months later, there is an indication from the Chief Executive of Arms Corps that we were asked for a performance guarantee. Now that is actually, it is actually nonsense. We were never asked before a performance guarantee in this bidding phase whatsoever. I still want to carry on with 227, but I'll give myself a break.
After you deal with this risk premium and the price that was eventually required of your company's IMS system, you then deal with the price in respect of which the Texas system, as you point out in paragraph 227, was quoted in the best and final offer. Please take us through that and advise what became of that.
Okay. As 227 says, with this untenable price of 89 million, clearly ADS and Thomson together had for actually a long time been talking to this other company, to Texas. Initially, it was a subsidiary of Dassault, but it became as far as I know, 100% owned Thomson Group company. And my understanding is that their system was also incorporated within the Thomson's TAVI-TAC combat management. I'm not sure of that, but that certainly had to have something in there. But in any case, so this became now a competitor, an alternative to the IMS, and quite where they got the price of 49. It's actually not 49.55. It's actually 49.255 million. Where they got that price, I've got no idea, but it was slightly higher than our own price and a lot less than the ADS's price. So clearly, it was much more attractive. But I think this is the relevant stage just to address the point of not being asked to include a risk premium. And in the proceedings of this commission, one of the witnesses has addressed this point, and it is recorded in the transcript of his evidence. That witness is Admiral Johnny Carmerman, and I've got that document in front of me. My understanding is that those documents are on the record. Certainly, if anybody wants to actually get the physical document, that can happen later. But it is on the record, and if I open that document up to the relevant point, I can read that particular response.
Could you please describe the document and perhaps where it is obtainable from the record and what the nature of that document is?
Yes, it is a document that I actually got in two forms. The first form is on the Commission's website, and basically they refer to it by date. In fact, I've concatenated the two transcripts of the 2 different days that the witness gave that evidence. It was the 26th and the 27th of May 2014. Unfortunately, the PDF version that was provided to me was unusable because for some strange reason, when it was printed to PDF, it prints alphanumeric characters with a space in between, which makes it impossible to digitally search anything in the document. So I requested the Commission, in the person of Advocate Ndumbi, who is the leader of research, to provide me with the original of that. I didn't expect to actually get the Word version, but I was given the Word version, which I've converted to PDF. And that's the version that I'm using in front of me, because that is converted to PDF by me, and it doesn't have all of these crazy spaces in between each of the alphanumeric characters making up the text.
What is the document you're referring to?
It's basically the transcript of Admiral Carmerman's evidence that he gave before the Commission on the 26th and 27th of May 2014.
Do you have the page numbers of the relevant passages of the transcript?
We do.
Could you furnish those page numbers for the Commissioner's reference?
Start reading from about halfway down, but it starts on page 6275. As you know, in the header of all of these documents, it's got APC in bold underlined, the top left-hand side, then the page number, then it says public hearings in capitalized bold underlined, then the dates 26th to 27th May 2014, and then phase 1. That's the document to which I'm referring.
So the page you said is page 6275 to...
I'm dyslexic. 6257.
Right, it's 6257 to page
8.
6258. You can deal with that now.
Okay, it starts at line 15 of that page of the record, and he says, secondly, and I think that's the nub of the whole thing. We wanted C2R2 bus on board because we had fed this child for 7.8 years. As a result of him not placing a risk premium in his offer to the main contractor, we were left with this indistinct. He was the only company of the 18 South African companies that bid their systems to the main contractor. that did not allocate a risk premium for the development of these systems. I had to move that. Sorry, the arrow makes it jump down a whole page. I have listed in my statement a whole list of companies such as Danell, which accorded almost 100 million rand because of the indistinct was immature. I suppose he means system or technology was immature. And they put that in their price. And that was the price the state, going on to the next page, was actually going to have to pay through the main contractor. Richard Young never put a cent on top of that because he said, quote, "My bus is technically proficient. It's my bus. It arises from my work being done as a PhD, and it has no technical risk." We tried very desperately to convince him that it was not so, and it was not a technical risk per se of getting data from one point of the vessel to another. It was the corporate risk of the main contractor having to assume the risk of performance with his bus, his immature bus on board. As a result of that, it was decided that senior members of the Navy and Arms Corps, in this case the CEO of Arms Corps, and our Navy officer, that's Admiral Howe, just below the Chief of the Navy, Admiral Howe, to go and try to reason with Richard. We had tried to reason with ... Now, there are a lot of extremely interesting, important things in that 1.5 or that 2.5 pages of evidence.
What are they?
Well, the first is that this child was fed for 7 to 8 years. That concords precisely with my evidence. This was 1999. It had been going on for the development, system engineering, both technology development, technology retention, and system engineering for Project Citron had indeed been going on for those 7 to 8 years. In those 7 to 8 years, we had developed this thing, the IMS, far further than a technology demonstrator. In fact, to be honest, to be frank, indeed, I never knew that I was developing a technology demonstrator. We were developing a system to put on board a naval frigate or naval corvette. And that is why we had got so far. If I go for a slight aside, but it is relevant, I talked about the system data bus that we developed under Project Winners, Project Rick, for the submarines. It's traditional in this kind of engineering, system engineering, that the glue, the integration mechanism that puts a system together nearly always runs 2 years ahead of the rest of the systems in terms of both system engineering definition and development. And I can say, we were actually running far more than 2 years ahead of the rest. It does come up in the evidence, but we would have finished the system engineering and development to all intents and purposes by the end of this year, 1999. It's referred to as coming to milestone 3. We got to milestone 3 not much later than this, where the system is basically fully tested. It's not fully qualified on board a vessel because no vessel exists. Not even an integration test bed exists at this early stage. But the IMS was a fully developed system. The next thing, the contention that Admiral Coleman, as he said, was the only company that didn't do so. Well, there are a couple of reasons for that. First of all, we weren't asked to do so. Secondly, we didn't need to do so. There were 2 years of cost and risk audits. There was plenty of opportunity if there had been seen to be a residual risk, then being required or recommended of making sure that risk is catered for in financial terms. But as I read out from the cost and risk audits last week. The risk was determined as low. That was the DOD's own position of risk. I certainly could never counteract that and say, well, it's not low, I'm adding on my own risk. How do I justify the risks the costs that I've been putting in for years, which was 29 million and then 38 million and then whatever? How do I suddenly start jumping to 49 million or 89 million based on risk? Based on what kind of risk? Certainly there was no business risk for me. Also, there might have been some talk of risk, as I talked about earlier this morning, but there was never any direct approaches to us to say, gentlemen from C squared, I squared, there is this risk, address it properly. There was loose talk about risk with us. There might have been tight talk with ADS, but certainly we weren't even involved at this level. The only involvement we really had was responding to the ADS best and final offer, request for best and final offer. I'm going to give myself a break there. I've still got more to say.
From the passage that you read, I seemed to pick up certain suggestions relating to approaches being made to your company to make provision for the risk. Do I understand your evidence correctly when you say there were no such formal approaches?
Absolutely no such formal approaches, and the only approach, and it's actually I took notes of this meeting. It wasn't even it certainly wasn't a meeting. It was a get-together, if I may say so, in the Admiralty House with Lou Swan, the CEO of Arms School, and Admiral Howe. And in that meeting, even though Lou Swan refers to them asking us to provide a risk provision, they actually didn't. It's just something that he concocted later. When I say that, when I say providing a provision for risk for the IMS, what is on the record, and just to show you the ludicrousness of this, he says is that they asked us to provide a risk premium for the whole combat suite. We'll come to that later. It was a letter written by him after he had left Arms School, and I think it was a letter written by Chippy Shake. Sorry, not by Chippy Shake, to Chippy Shake. But just think of the ludicrousness of it. Even if we were asked to provide a risk premium, we'd be asked to provide a risk premium for a 2.6 billion rand combat suite, when we are offering a 38 million rand excluding VAT price for an IMS. The profit that we might have made on it, gross profit on that, might have been, 30%. Say 38 million, say 12 million, 13 million net profit, half of that at best, 5 to 10 million profit. What company MD is going to provide a risk guarantee for a 2.6 billion rand? It is so ridiculous that whatever the evidentiary value that letter might have has got no logical value whatsoever. If I may, I don't want to lose my train of thought. But anyway, that meeting was held. I think it was actually held following the August 99. Now we're talking about May 99. The August 99 Project Control Board meeting. Certainly at one of these Project Control Board meetings, that instruction to meet with me was held, and that meeting, that let's call it a get-together because it wasn't a meeting, was held not shortly after that. But that is far, far, far too late to be addressing anything regarding risk, whether it's risk for the entire combat suite or more appropriate as it should have been, asking us for a provide risk premium or risk addition or risk contingency for for the IMS itself.
Do I understand you correctly to say that the letter that was sent was requiring C squared, I squared to provide a risk premium for the entire combat suite, or for the IMS that it was quoting for?
No, just to be clear, this wasn't a letter sent to us. This is a letter that I have discovered. It was a letter sent, I think, from Lou Swan to Chippy Shake after Lou Swan had left Arms Corps, where he recalls discussing this risk premium. I'm working now from memory. I'm not 100%. But anyway, what I will categorically say is that we were never requested in writing to provide a risk premium. This is just a recordal of something by the by. May I carry on? Okay. Now the point of is, as Admiral Carmerman says, Richard Young never put a cent on top of it. Well, I didn't put a cent on top of it that was visible to him. And it's not as though I'm trying to allude to anything that I was doing. We don't necessarily put, when we deal with risk, you don't necessarily only deal with by just putting lump sum money, cash on top of it. But risks can be handled in many different ways. Here, we already had all the hardware for the development of the IMS, and all the hardware that still had to be bought would have been bought at the project. So there was no necessity to make a provision even for set aside money to buy anything. Everything was involving, let's call it, intellectual property development. So certainly there would have been sufficient man hours, which of course get included in the IMS best and final offer in the budget. And there certainly was sufficient man hours to complete the development, to complete the formal qualification for the IMS, and for some kind of contingency for things not being done. So it would be a completely incorrect statement that no risk had been provided for at all. It certainly wasn't cents worth, it was maybe man hours worth. But also his contention here, I have to be honest, I have to be frank. The thing about my response, this being a quote, my bus arises from my work being done as a PhD. This is complete unadulterated nonsense. We're talking here of 99. My PhD was handed in July, I think it was the 8th of July, 96. That's 3 years before this. The work done was finished about a year before that. I was only, one takes 6 months to a year to write up a 450-page PhD thesis. Okay, and indeed, most of the work actually had come out of my MSc, which was done in 1992. So there was never any discussion whatsoever with Admiral Carmerman that he would be allowed to quote me as saying that this risk issue has got anything to do with my PhD. I have to be honest. This is completely. This just isn't the truth.
Is there any further comment you need to make with regard to the passage?
Desperately to convince him. This is also just isn't the truth. There was no desperate. If there was anything desperate, it would have been done on paper. Whether maybe one could say that at this point the JPT is a level 6 entity. It's not communicating with level 3. We were level 3, and so I see there's a context of us being only a subsystem somewhere, level 2. So we get dealt with by GFC or ADS. But if there was something desperate here, now we are a baseline system. There would surely have to be something in writing to say, we desperately need you to increase your price to include risk. But anyway, like many of the statements or vermins that come up that are totally relevant, this is totally bald. Where is a reference in the evidence documents that are supporting this witness statement, or at least the transcript of the oral evidence that supports such a contention?
You have dealt with the passage exhaustively, or is there anything else you need to add there?
No, I agree. It is exhaustive just in this particular context, but it'll probably raise itself again.
Shortly before we resumed the proceedings today, you requested certain letters to be printed that you needed to refer to. Would this be appropriate time to refer to those letters, or perhaps after tea?
It would, in the terms of logic, be in chronology appropriate time, but I'm not 100% sure whether there were two ones that I indicated to Advocate Sello that were very important to the statement coming up. I'm not quite sure whether those have been printed. I know there were photocopy problems, but certainly if they haven't been properly printed and numbered, then this would be an appropriate time to allow that to happen.
Chair, there are letters that have been copied which I think deal with the theme that the witness is testifying on now. Copies have been made. We would just like to perhaps number them for purposes of the record, so that we can deal with them properly. Would this be an appropriate time to take the tea adjournment?
Advocate Sibeko, I see it's 10 to 11. I think maybe go to the next point, because I only intend breaking for tea at 11:15. We need to make up time.
As it pleases the chair.
Okay, if I may say, that's not bad at all, because we don't have to come to those two letters straight away, because as my witness statement says, we still have the document indicated as RMY 97, and certainly to traverse that, I didn't know he was coming up at 11:15, but without losing the chronology of this evidence, we can carry on with that before having to go to a completely different point.
Paragraph 227, I think we have dealt with this.
We haven't dealt with 226 yet. Sorry. You're right. My cursor made the 8 look like a 6. Sorry.
We then go to 228.
Sorry about that. Okay. I now have in front of me, and it is in evidence document indicated as 97, which is we're going to come to in the future. So it's looking forward in your bundles. So maybe I should just stop to make sure that you can, because it's not the next one in the bundles, but it might be in. I'm not even sure exactly where it is.
Are you looking for RMY 40?
Looking for RMY 97.
Dr. Young, that would appear at the end of paragraph 466 of your statement. Would that be correct, at page 117?
I think so, because I've got a note here looking forward, but I don't want to go there and then I'll lose my place here. But I do remember it comes up in one further instance, so I would guess so, yes.
Yes, in terms of the notations made, that is RMY 97. That appears, that annexure is in file 5 at page 1858. Dr. Young, the document you're referring to is a letter on ADS, letterhead, dated 24 May 1999. Is that correct?
That's correct, yes.
Right. What is it that you want to deal with in this letter?
Quite a lot of things.
You can start now.
Okay, so let's address to the project officer, Project Citron, Captain Carmen of the Department of Defence. It is a best and final offer for the Project Citron Combat Suite. Is certainly a letter regarding it. Whether it's the whole best and final offer or not, I see it's 11 pages long, but it certainly addresses their best and final offer. As I have first of all stated before, I want to address the issue of price increases, because it's so important to the deselection of the IMS. I also want to address the point of the price of the surface-to-surface missile and other items making up the price and making up the price increases and price reductions. As a starting point, as I've said in my own witness statement, ADS's best and final offer also proposed to remove the ammunition, which will include the surface-to-surface missile rounds, from the offer in order to bring down the price of its offer by approximately 300 million rand. And it's not that I'm saying so, that's what the letter says. I've quoted one particular sentence of it, which says, in order to further close the gap, the removal of ammunition, except for the system qualifications, will result of a saving of approximately 300 million rand at the level of acquisition costs. Now, if we start off at the where it says close the gap, obviously the gap at this stage is the expectation of price. One can say one of the expectations might have been the 1.9 billion. There is various documents on the record in which I've discovered and I'll be addressing, which show that the expectation at this time was, well, at one time at least, was 2.3 billion, with further price reductions expected, which would have brought it down to, I think, a maximum of 2.1 billion. But certainly, a later expectation was the one finally arrived at, which was 2.599 billion. Let's talk in round terms, 2.6. And at this stage, the 2.6 excluding VAT. So the gap is the difference between around 3 billion and 2.6 billion. So there are obviously some fairly major things had to be done to achieve that. So if I open the document here, we also have a ventilation of the whole issue of something that came later in the project, which was Part B's and Part C's. To put that in context, Part B, let's call it the second part, was the combat suite. and then that further got divided down into the Part B, which would be provided by Thomson ADS and include the whole integrated combat suite, and Part C, which was the part provided by the South African industry, which would then, where the risk would be taken by the state, that being the DOD, for want of a better term. And then once those were fully qualified, they'd be handed over to ADS and Thomson as qualified subsystems, and then integrated, and then also becoming part of Part B. Then we can go on to the next more important part, is the paragraph starting with "we understand." Now this is ADS perspective. We understand that the main driver is the price, which needs to meet the South African Navy and Armed Corps budget expectations. You alluded to, Evidence Leader, you alluded to that at the beginning, well, in this question. Although every effort has been made to reduce the price to the expected level, in brackets, a reduction in price overall of about 1 billion rand has been achieved through the reduction in scope that you have accepted, as well as price reductions from our side. The enclosed price does not meet the expectation. Now, analysing this, it's clear, obviously, that is correct. The price does not meet the price expectation. Certainly, as we discussed on Friday, is that the Navy, in this one letter, I think it was the one, it might have been part of this request for best and final offer, where it says that the joint project team representing the DOD had accepted a substantial reduction in both quality or quantity and quality. And indeed that is true, and it is actually ADS is saying that themselves here. And although we might come to it, the initial prices that ADS and Thomson issued for this combat suite in response to the expectation, the adjusted expectation to 1,9, their initial quotes were 3,9, just 2 billion rand more. 1,9 to 3,9, more than the expectation. So certainly there had been substantial reductions in scope of supply to meet that. Certainly I am unaware of any price reductions from our side being ADS's side. I've only seen price increases, and I'm pretty sure that is borne out by the previous letter that from written by Admiral Carmerman that we've just addressed in some length.
A discussion of that letter would then bring us to the aspect relating to the evaluation and selection of the data pass. Is that correct?
Yes, it would. But before I want to show the next sentence, which is probably blocked in a highlighting block, which is the one which I read out. And to me, it is highly interesting, if not fundamental. Quote, in order to further close the gap, the removal of ammunition, except for the system qualifications, will result in a saving of approximately 300 million at the level of the acquisition costs. Now, I discussed the significance of the SSM and the pricing and the redaction with which I was trying to deal to make head or tail of this. But this is certainly a very valid indicator of where things either did go or certainly were considered. And it certainly is one of the pointers which I've used to try to come to my own conclusion. Now, as I've said before, by this stage, the price had decreased from 3.9 billion to around about 3 billion or 2.9. The whole issue of VAT is always problematic. I understand VAT, but I can never understand whether figures include them or exclude them. Not never, sometimes I don't. But anyway, it was fairly clear, as I said, the final price arrived at was 2.6 billion. And it just seems interesting that by removal of the ammunition of 300 million, they were able to achieve a price that was eventually agreed at of just over, it was agreed at just over 2.6, but eventually signed at just under 2.6 at 2.559. So I think that this is an interesting point of departure for that particular ventilation of that aspect of the evidence. I don't need to necessarily belabor the point, but two paragraphs down, in the middle, there is the point I addressed about Part B and Part C. In this particular point, they talk about Part C except for the IMS. Now, there is evidence showing that originally the IMS was considered as a Part C, and here it is being included as a Part B. And there's a good reason, well, maybe two good reasons, but certainly one of the good reasons is that the IMS, we addressed this on Friday, is now being included within the TAVI-TAC combat management system. The architecture is being changed to basically include the IMS within a subsystem, not as a combat suite element, but as a integral. Now, this is where it would be as a subsystem of the combat management system. Now, the combat management system was coming from France, or Thomson CSF France, okay, with some modifications. So it's clear, by clear dint of logic, as they say in legal speak, if the IMS was now part of an element which was Part B, then it would also have to be Part B. So if it was a Part B, this is one of the reasons why there was a risk premium added to the IMS.
And who would be responsible for the payment of the risk premium in those circumstances?
That's correct, yes.
Now the question is, who would be responsible for payment of the risk premium in those circumstances?
Yes, I think there are various aspects of looking at that, but maybe the de facto, de jure, if that's the right word, one is now what Cabinet, MINCOM said, is that the state is not going to be paying for that risk premium. Of course, they were prepared to pay for many other risk premiums, but not for the IMS one.
Would your company have been responsible for the payment of that risk premium in these circumstances?
Certainly, if we'd been asked for a risk premium, and in fact, indeed, later, there's a letter which is addressed with by various people in this particular forum and in Scopa with great glee, if I may say so. And certainly we will address that letter, where they refer to a risk premium which I had determined, but if I say so at this point, so nobody gets overexcited and gets me out of context. When the ADS changed the architecture and included other things we talked about on Friday, unfortunately technical things like bridge interface units and dual protocol stacks and all of those kind of things, and basically fundamentally changed not only the technical baseline at that stage, but the baseline to which the IMS had been developed and existed and design reviewed at that stage. Then I talked about adding a risk premium of 35%. Okay. Now, if a risk premium of 35% at this stage had been either added on voluntarily by me or in response to these desperate requests by the JPT, either directly or indirectly, then adding on a reasonable risk premium could certainly have been done. But I would never have added on a risk premium of 49 million because I just couldn't justify it. Possibly the risk premium could have included a 10 or 12 million rand thing for the IMS study. I don't quite know how you would determine a premium for the IMS. In fact, I thought I did so in a very elegant way in that letter, which I think even Chippy Sheikh addresses in the response, his response to these to the Commission. Sorry, excuse me for a second. In fact, maybe preempting that letter at this stage, what I said is that there was still, we're talking about 99 now. By the time an IMS had to be delivered into the integration test bed, or even to ADS to start integrating its own stuff, the RQR reference set or whatever it was, the thing that I referred to on Friday, and there was still a certain amount of time. And there was not only a certain amount of time to technically address these risks, but if, as De Texas had said, they had this Diacerto database working on a French aircraft carrier, then it shouldn't have been too difficult to do a technology insertion from there into the Corvette combat suite if our one failed. So my proposal there was, and talking about a reasonable risk apportionment in terms of money and in terms of approach, say, okay, well, it's going to cost some money to do this risk reduction. You don't get that level of risk reduction at system level. And I'm not talking about here what I said earlier about having a contingency of man hours to sort out products. That's a different issue. It costs money to sort out risk issues, especially risk issues that are introduced by another party, this being ADS and Thompson, to suit their own ends, which is to include the TAVI-TAC combat management system. That's the reason why there was a risk. But be that as it may, what I said, if we embarked upon this CS7 Mod 1 architecture, which included the bridge interface unit and the dual protocol stack, etc., if we didn't get to it within the time scales that I was indicating, which I think was about 2 years, and we then demonstrated a true risk in terms of timescales and cost and performance, which all together might add up to a true business risk or commercial risk or level 4 risk or 5 risk or 6 risk or whatever, then we would withdraw completely, keep the money that we'd been paid, which wouldn't have been that much because we would have spent that money on risk reduction, and not demand any further money or participation. Now that is a fairly serious thing for an MD of a company to say, who owns his own company. That is really putting one's money where one's mouth is.
I'm sorry, Dr. Young, to interrupt you. Are we still talking about risk? I thought we were under the topic evaluation and selection of the database. I suggest that we spend too much time on one aspect.
Excuse me, my evidence leader actually asked me a question about risk, so I was responding to his question. I think we still are overall on risk, but I respond to the questions put to me.
And of course, no one wants to limit your scope of testimony, but we've got time constraints as well.
Unfortunately, I will have to address my evidence as it's set out before me, and not everything is set out before me in my witness statement. I've got a lot of documents. I have to address my evidence the way it is before me, however long it takes.
I suggest we have to find a way of trying to shorten things and get to the point. Look, we've been sitting here and we've dealt with only 1, 2, 3 paragraphs of your statement since the morning.
I understand that, but I have to put it on the record, seeing that you are asking, is for the last, in fact, ever since I started dealing with advocates Skinner and Sabaya, is that I've said that my evidence in its totality, just in chief, was more likely to last something like 3 weeks. We're going to try and limit it to much less than that. But nobody should be under any misapprehension about the length of time that it's going to take to traverse my evidence properly.
Just as a remark in passing, Dr. Young, there's no advocacy buyer that who ever worked for the commission. I only know about advocacy buyer, not Sibaya.
I'm sorry, did I get my pronunciation wrong?
Right. Having dealt with that aspect, this would bring us to the evaluation and selection of the database. Would you start with that, please?
Sorry, Advocate, are you talking about now my witness statement or the rest of this letter?
Oh, are you still dealing with that letter? Or are you?
Well, seeing that the data is in front of, I just have to address it now. It puts things that are coming up in context. That's the way documents work, unfortunately. The last sentence of the letter puts it in the context of what I said about reduction of price. Anyway, it says that should the South African Navy and Arms Corps accept the above recommendations, then the price of the combat suite shall be reduced to 2.516 million rand. Now, obviously, what they're talking about, the major share of that is the 300 million rand reduction in the removal of the ammunition.
And this would relate to the missile blocks, is that correct?
Well, the lion's share of the cost of the ammunition is the surface-to-surface missiles. There is other ammunition, but it's relatively small by comparison. We have come to the end of that letter now.
Would this be the time to then deal with the evaluation and selection of the database?
Seeing that you are now dealing with a new paragraph, maybe it might be an appropriate time to take a tea adjournment. Can we come back at 11:30?
Yes, please, the Chair.
Thank you.